So the jury verdict is in. Trump's been found guilty. Look, this is a momentous case. Everybody's talking about it. Most people don't fully understand it, but here's something we all know. It's a dangerous precedent. Nobody wants it to be the rule in America that if you're a former president or if you're running for president, you become a target for criminal prosecution. It is hugely important that if there is a criminal prosecution, it be done lawfully and constitutionally.
What I'm trying to do with this, this podcast, the YouTube, the X videos, I'm just trying to explain to folks what's happening. There's so much partisan stuff. We've got to have a way of talking about serious legal issues in a nonpartisan way, and so that people can understand it, think for themselves. I wouldn't say that what I'm doing is attracting a big fan base at Yale Law School.
All right, guys, welcome to Friday's edition of the Sean Spicer Show. What a great show I have coming your way. So if it's late enough where you are, I know it's, evening time on the East Coast. And I'll tell you what, if you're on the West Coast, it's okay with me if you want to have a adult beverage right now. If you're watching us anywhere else in the world, well, guess what? As they always say, it's 5 o'clock somewhere. Enjoy. Let's kick it into high gear and get ready for the weekend. What a breakdown today. I've got Professor Jed Rubenfeld on the show. He has been putting out a series of videos about the Trump legal case that break it down in a very methodical and logical way that I hadn't seen before, at least. Here's the kicker. He is a Yale professor. I mean, I can't imagine. And he is not a Trump guy, at least that I know of. He's just a smart lawyer who teaches constitutional law. And he's going to explain to us what the basis of Trump's case for appeal is. And I'm going to ask him all the questions that you guys email me and send, which is like, what about the letter that the judge got or put out to the parties? What about his conflicts? What about the daughter? What about the fact that Trump didn't even know what he was being charged with? I'll ask him all that because that's what I hear from you guys all the time. So I'm going to ask him that today. Before I get to that, though, things can go sideways. You can imagine Trump's world. I mean, that went sideways. But for us, most of us, going sideways is just losing power. I've talked about this over and over again. Like the last couple of weeks here in Virginia, it's been like a constant. We've had a tornado watch, hurricane. I mean, not hurricane. We have tornado watch, a lot of crazy weather. And if you think about it, I've done this in the past when my kids were little. The power went out for like 5-6 days, and I'm running to the gas station. There's two in our neighborhood. One was closed, one wasn't. I'm hoping to fill up the little red thing and get back. And that body's so many hours. I had it down to a timing. Like, okay, this is how long that's going to buy me, and I can only hook up so many things with the cords. But now I have a Patriot Power Generator 2000X that you can get at 4patriots.com/Spicer. And I'm set. No more gas. This thing runs off a solar panel that comes with it for free. You get the solar panel. No more running. And the cool part is you don't have to worry about the fumes and the noise. You can bring the Patriot Power Generator into your house. And it powers everything for hours. And when I mean everything, the refrigerator, phones, computers, medical devices. And the cool thing is even I can lift it. Now, I've been doing a little working out since the new year, but like this thing is completely portable. So if you had to bring it somewhere, whether that's to an event or to a friend's house or a family member's house, you're totally set. Again, no cords, no fumes, no gas, solar panels power the whole thing. Patriot Power Generator 2000X. Don't wait until an emergency to wish that you had this. Go to 4patriots.com/Spicer now and get ahead of the curve. All right. I want to bring in our guest right now. As I said, Professor Jed Rubenfeld. He is unbelievable when you watch the videos. He is the host of the Straight Down the Middle podcast. You can get it on X, Spotify, YouTube. He puts the videos out, and then he takes a bunch of questions and he answers them. It's fascinating. I came across him. I love him. I'm like, I got to get this guy on the show. As I said, he's a professor of constitutional law at Yale. Can you imagine that? How that goes over? Anyway, unbelievable analysis of the Trump campaign. Let me bring him in.
The Trump hush money case. So the jury verdict is in. Trump's been found guilty. Look, this is a momentous case. Everybody's talking about it. Most people don't fully understand it, but here's something we all know. It's a dangerous precedent. Nobody wants it to be the rule in America that if you're a former president or if you're running for president, you become a target for criminal prosecution. It is hugely important that if there is a criminal prosecution, it be done lawfully and constitutionally. I'm Jed Rubenfeld. I'm a law professor at Yale Law School. I write and teach and litigate about constitutional law. And I'm going to tell you that there are some serious constitutional problems with this case.
All right, here's the man behind that video. Professor, thanks for being with us.
You bet. Thanks for having me.
I want to get into the why of the videos in just a second, but let me just start with this. I think it was one of the things that fascinated me among the questions that you answered is, would this case have been brought against anybody if their name wasn't Donald Trump? That's you brought it up. You get asked that question a lot. I've been asked that question a lot. Would anybody else have been prosecuted for this case?
Well, you are asking the right question. And I've got to think that most people, I don't care which side of the aisle they're on, have a suspicion or can see, because it's just common sense, that this prosecution would not have been brought if it hadn't been Donald Trump as the defendant. I mean, after all, it was a novel theory of prosecution. Folks have studied this, and they can't find a case in the past where the Manhattan District Attorney has brought a case like this one with these particular mix of kind of very confusing charges. And the charges are darn confusing. I mean, normally criminal trial, somebody's supposed to have robbed a bank. There's a prosecution. If they're convicted, okay, you know what they're found guilty of. They robbed a bank on such and such a day, and nobody's confused about it. You go out and you ask, 100 people, what was Donald Trump just convicted of? 99 people say, I can't figure it out. And you know what? 90 lawyers will say they can't figure it out either out of 100. And that's very unusual and strongly suggests that something, look, we've got a district attorney, ran for office as a Democrat, said he was going to go after Trump, used those words, go after, and then prosecuted Trump on a novel legal theory. And Trump is, the leading candidate for the other side. That's what's so troublesome about this and why it's such a dangerous precedent.
I want to break down a couple of the things you get to in the videos in a second about selective prosecution. And also this idea of running for office under that, because I think that's it. But the first thing I want to start is something that I haven't seen you address, because maybe it's not even that big of a deal to anyone but me. But I look at New York City, and you look at the office of the district attorney under Alvin Bragg, and they keep taking felony charges and reducing them to misdemeanors, right? So you see these events occur in New York City, some of them public, some of them captured on social media, that are felonies, and they're pled down to a misdemeanor. This was the reversal. A misdemeanor, 7, 8 years old, pled up to a felony. And I've got to think to myself, and maybe this ties into the other questions that you've been asked, but wouldn't the normal person walk in and say, you've got to be kidding me. You're downgrading these actual felonies, people hitting somebody, robbing somebody, committing an act of vandalism, whatever it may be. You're pleading these down to misdemeanors. And in a city of whatever million that New York City is, you're going to take me to trial for a bookkeeping offense? Isn't that in itself something that the lawyers would have used as an argument?
I think they could have used it. I know just what you're talking about. Early in Bragg's, early after he took this office, Manhattan District Attorney, he started announcing policies of not charging not prosecuting numerous crimes in New York, and he's kind of well known for what, just as you're talking about, reducing or not prosecuting, what would otherwise be felony charges of, sometimes serious criminal offenses, street offenses. And that makes, that raises for a lot of people suspicions too. But Sean, the problem in the basic legal problem with the question you're asking, couldn't they use that to prove selective prosecution? That's the legal term for it, selective prosecution. Is that, courts have made it super hard to prove. You've got to almost come up with a set of comparable facts where somebody did something very similar, but was like on the other side of the political aisle or had different political views, and the office did not prosecute them. And courts sometimes say, look, you got to show us a comparator like that before we're going to accept a selective prosecution claim. And the extraordinary thing is there might be a comparator like that in this case. You want me to describe that?
Yeah, please. Because can you so the point that you're making is that if you're going to argue this, that, hey, you're going after me and you didn't go after anyone, you have to have an apples to apples comparison, right? You have to say, look, you didn't prosecute someone of the other party who did a very similar thing. Isn't that's kind of what you would need to have, right?
That's exactly the point, because constitutionally speaking, what's unconstitutional is to go after somebody out of hostility toward or in retaliation against or an attempt to suppress their political activity. That you can't do. That's
And you have to
unconstitutional.
prove that, right? I'd have to say, I know that DA Bragg, in the back of his mind, he really hated me. But couldn't you argue that, hey, here's a campaign ad? He literally campaigned on this.
Yeah.
Is that proof?
That's evidence. It's evidence. But what courts want to see as proof is show us where somebody else did the same kind of thing that you are alleged to have done, but it was someone with the opposite political views, someone from the other party, somebody whose views maybe the district attorney's office favored, and show me that they didn't come after them, and show me that that event happened at around the same time as your events. And that almost never happens. But as I was just saying, in this case, there might really be that extraordinary comparator. And I'll tell you, what happened. So the Clinton campaign, so this is the same 2016 presidential election. Amazingly, in 2022, the FEC, Federal Election Commission, determined that the Clinton campaign had booked, had written down, had recorded in their own business records certain campaign expenses as legal expenses. Those campaign expenses, by the way, that was the funding of the Steele dossier. You remember the famous Steele dossier?
Very personal.
Yeah, and we didn't know it at the beginning that the Clinton campaign had funded that, but it turned out they had. And what they did was they booked it as a legal expense. And the FEC in 2022 said, you can't do that. That was false, and we're going to fine you for it. And they did fine him for it. Now, at the core of the case against President Trump, it's all very complicated, but at the core is a claim that what he did was to record as legal expenses what was actually a campaign expense. That's the state's allegation. The $130,000 in hush money that was paid to Stormy Daniels. The state says, hey, that was actually a campaign expense. You're trying to help your campaign, but you recorded it as a legal expense. It's surprisingly similar to what the Hillary Clinton campaign did at the exact same time. And that campaign was based in New York. And I'm just basing this on public documents. I don't know anything more than the rest of the public. But what's surprising here is that District Attorney Bragg never seems to investigate, certainly never prosecuted Clinton or anyone in the Clinton campaign for what appears to be a very similar offense. And that will be Exhibit 1 when Trump's lawyers argue that we have proof that this is selective prosecution.
All right. I hope you're enjoying the conversation. Sorry to interrupt it, but can you imagine you get a knock at the door right now and it's the IRS? That would interrupt the conversation, wouldn't it? And because of the Democrats spending, there are tens of thousands of new IRS agents that are sending out over 5 million pay up notices. What does that mean? Because of the pandemic, a lot of people weren't paying their taxes, business, personal, or got behind in them. Maybe it's a few thousand, maybe it's a million. Who knows? Depending on what you're running. Tax Network USA can be your friend. When that knock comes, that call comes from the IRS, do not take it alone. Call my friends at Tax Network USA, 1-800-245-6000, or better yet, go to taxtnusa.com/Sean Spicer. Full name on that one. Got to get the full name in there. tnusa.com/Sean Spicer. They have saved their clients over $1 billion, because they know what they're doing and they have the expertise. You do not want to face the IRS on your own if you get one of these letters or calls, because they have nothing better to do than turn your life upside down. Luckily, the people at Tax Network USA know exactly what they're doing and have a strong, long record of helping their clients. Call them or go to tnusa.com/Sean Spicer to find out exactly what I'm talking about. Now back to the conversation. So here we are. The sentencing is scheduled for July 11th. What and when? So just taking that issue alone, right? And you say, I believe we were selectively prosecuted. Here is the Clinton campaign example, as you cited, that we're using. Do they file an appeal now? Do they wait till sentencing? And does that go to the New York, or is that something that is a federal issue that you would try to seek the Supreme Court out on?
Great set of questions. In the normal course, what they would have to do is they would have to wait for Judge Mershon to issue his judgment of guilt and to impose sentence. And that is all scheduled to happen on July 11th. On that day, Mershon will say, I'm sentencing you to jail. You're going to jail for 30 days, 60 days, whatever he wants. Or he'll say, I'm putting you on probation. Whatever sentence he imposes, Trump's lawyers are almost certain to ask for a stay of execution on that sentence. They will have to do that first at the New York Appellate Division. That's the first level of appellate court. If that court says no, they will then appeal that to New York's highest court, which is called the Court of Appeals, but it's the highest New York court. And if that court says no, then they can take that appeal up to the Supreme Court. They could even try to jump these appellate level New York courts and go directly to the United States Supreme Court. But that's, there's no guarantee the Supreme Court would take it. There's no guarantee they could do it. In the ordinary course, they'd have to go through the New York appellate courts to get the Supreme Court. All that's going to take time. It could easily, if you just follow the normal course here, you don't get to the Supreme Court probably until after the election, which is a very serious problem. Because if this...
Well, look, that goes to something that I've been arguing for a long time, which was this was never about actually punishment. This was about a bumper sticker. And I know that's more of a political question than a legal question. But I've always believed that they just wanted to be able to run and say Trump is a convicted felon. We all know that the appeals process is going to take months and will likely not resolve itself until after the election. But from a political standpoint, which is more my world, I believe that was their goal, is to have the ability to say, we're running against a convicted felon. Don't vote for a convicted felon, because by the time he may or may not be exonerated, it'll be well past the election. Again, that's my political theory on this. I guess, though, that the next question would be, so you've got the selective prosecution angle, right? Your example that I think holds a ton of water shows that it's a federal issue, though. It's the Federal Election Commission because they were running for a federal office, President of the United States. Could they also make the case at this juncture that, hey, you, Alvin Bragg, in New York City have no jurisdiction over this? You combine this potentially with a federal issue that you don't have the jurisdiction over.
Yeah, a lot of people are saying that. You certainly read that in some of the legal commentary. My guess is that the lawyers will make that claim because of the incredibly convoluted way that Bragg structured the charge. It may be that he can escape that kind of federal preemption argument. What he did was he charged a state offense of falsifying business records to conceal a second state offense, a New York election law violation, which then could refer to one of 3 or 4 different possible other violations, so convoluted, one of which was, the federal campaign finance violation, one of which was a federal tax violation. So you only get to these federal offenses going down this long chain. And what he could say is, the New York law is not, I didn't do anything I wasn't allowed to do. So I survived that federal preemption argument.
So let's pull that thread for a second, because I know you addressed this in some of the Q&A in the videos. I've always believed, and I know you brought this up, that if you're going to charge me with something, I need to be able to put on a defense. You say I killed somebody. You say I vandalized someone. I stole something. I need to be able to say, no, I was not at the location where you say I was. That wasn't my weapon. My fingerprints aren't there. They didn't charge him with any of the offenses that they used to build off of this misdemeanor charge, did they?
No, you're exactly right again, Sean. So this is a Sixth Amendment problem. Sixth Amendment, the United States Constitution guarantees every accused in every trial the right to know in advance exactly the specific charge that the state's coming after you for. And here, Bragg hands down this indictment. This is back in 2023, that says, okay, you falsified business records to conceal a second crime, and that's part of the charge. But he won't say what the second crime is, and he refused to say. And for months and months and months, nothing was said about it, and the state refused right up to the day of trial to identify specifically and say, okay, this is going to be the second charge in the case. Instead, they threw out a bunch of theories, and some of those theories were open-ended, like the one I just talked about, which made reference to yet a third level of possible charge, and they wouldn't say what that third charge was going to be. So all of that, by the very end, by the last day of the trial, the judge says, okay, the second crime is this New York election crime. But that's way too late. I mean, you got to tell the defendant in advance of the trial what he's charged with, not.
Well, right, because I want to. If I'm charged, I need to be able to put a defense together, put up witnesses. I mean, I kept thinking about it after listening to one of your videos, and I kept thinking about it in the context of a game. Right? Imagine you're playing football. I don't know if you're a football fan or not. I'm a Patriots fan. Imagine the game gets played, and at the end of the game, they say, "We've changed our mind. Field goals are now worth 8." And you go, "Great, we won because we kicked 4 field goals." You would say, "This is ridiculous. I would have kicked more field goals if I was the other team. I would have blocked those. I mean, whatever. You would have changed it." I kept thinking to myself, wanting to jump through YouTube and, in one case, Spotify, that I was listening to the audio version. Pretend I'm sitting in your class right now, and I raise my hand and I say, "Professor, I don't understand this. You've taught us about the 6th Amendment. How did they get away with this? How did the judge not say, 'Hey, Alvin Bragg, 6th Amendment, you have to tell the guy what he's for'?" It seems to me that there was a piece missing of this trial where somebody said, this is against his 6th Amendment protections, rights. Why was it allowed to go further if this is so open, it's so blatantly out there for all of us to read?
Well, I tell you, it's hard to understand, but what looks like it happened to me, just reading the court opinions, is that Judge Mershon made his decision on the basis of New York law. It looks like there are some cases out there where New York courts have said, "Hey, when the state charges this crime, falsifying business records to conceal a second crime, we don't have to tell. We don't have to tell anybody what the second crime is." And Judge Mershon expressly rules in February that the state, he says, doesn't have to identify the second crime. And I think he based it on New York decisions. But of course, the Constitution trumps, if you'll excuse the word, New York law. The Constitution is superior to New York law. It doesn't matter what New York law says judges can do. What matters is the 6th Amendment of the United States Constitution says this is something that judges can't do and prosecutors can't do. And that's, so the 6th Amendment argument makes New York law irrelevant. I think what happened was Mershon was looking at New York law.
Okay, fine. He's looking at New York law. I've never taken your class, right? I get all of my legal understanding from watching Law and Order. And I sit here and say, I can't see how that holds up. They're going to immediately appeal to the Supreme Court or go through the processes you've described. That, to me, in itself sounds like a pretty strong grounds for appeal. I mean, that in itself, I didn't know what I was being charged with. I couldn't put on a proper defense. Is that, where does, like, if we can pause in the same way we did earlier, walk me through, if you're Trump's attorney right now, do you go, great, this is what Mershon said, I get it, but this is strong, and we can go, straight to the Court of Appeal or to the Supreme Court. What do you do with that?
Well, I tell you, I've been saying for a while that what they should have done is they should have filed an action in federal court, federal district court, and said, look, something unconstitutional is happening over there in state criminal court. And here's what it is. It's a 6th Amendment violation. They cannot be prosecuting us without telling us what the specific offense we're charged with. Here's 150 years of Supreme Court precedent saying so. They're violating it. And I think they could have done it. They didn't do it. I think there's even a little window now where they could still do it. They could go to federal district court. They won't be able to do it after the judge pronounces a sentence on July 11th. It'll be too late then.
So we got a window. We got a window right now.
I think they've got a window. But
But if they don't, is that grounds for appeal?
If they don't
do what you're saying before sentencing,
yeah,
Mershon's issues the sentence. At that point, can they then use that as the basis of an appeal, or is that
absolutely? The Trump's lawyers will, I assume, say to the appellate courts, this whole trial was unconstitutional from the get-go because they violated Mr. Trump's 6th Amendment rights. And what the state's going to say is, what are you talking about? Back in February, we listed 3 or 4 different theories of what that second crime might be, and the one we actually went on was one of them. And the problem is one of the problems is that one of those theories was, as I was saying, the one, and it's the one they went on, was open-ended. It said the second crime was, hey, if you tried to influence the 2016 election through another crime, we can get you for that. And they never said what the third crime was. They never limited it. So Trump's lawyers had to go in having to guess what charges they would have to face, and that's what you're not supposed to. That's what a state's not supposed to be able to do somebody under our Sixth Amendment. Let me add one more thing.
Yeah.
See if you want to ask about this too. The judge in his final jury instructions says to the jury, and guess what? You don't have to be unanimous when it comes to that final offense. The state has now said it's going to prove to you that Mr. Trump conspired to influence the 2016 election by committing another offense through unlawful means. And you, the jury, you don't have to be unanimous about that. Two of you could think it was the unlawful means was a tax offense. Two of you could think it was a campaign finance offense. Three of you could think it was a New York business falsifications offense. It could be non-unanimous, and that's fine. And that is another constitutional problem that I am certain that Trump's lawyers will argue, and it's a serious one.
I agree, and I was going to go there I'm glad you brought it up, because I feel like it's saying, look, we don't like this guy, and there's a bunch of reasons that you might not like him, and so pick one, and as long as you all agree that you don't like him, it doesn't really matter why, just that you don't like him, and then that's good enough for guilty, right? That's at least from a layperson the way I looked at what happened. But it goes back to this idea that you aren't able to defend yourself and saying, okay, you may not like me, but I didn't do this crime. You may not like me, but I didn't do that crime. This just gave them like a buffet to go run down and say, I'll take a little of this, I'll take a little of that. As long as I feel like I'm full at the end, that's good enough.
Yeah. And so, again, it's a constitutional matter. The Constitution gives every criminal defendant, whether in state or federal court, the right to a unanimous jury verdict. And it's not just the overall verdict, like guilty or not guilty. They have to be unanimous as to each element of the crime. And at its core, what that right is, it's a right not to have a divided jury where some jurors find some facts that amount to one offense and some jurors find other facts that amount to a different offense. And they combine those and the jurors say, yeah, we find him guilty, but it's non-unanimous. There's not unanimity with respect to any specific offense. And it looks like that's just what Mershon invited them to do. So that's going to be a very serious constitutional argument.
You were a former assistant attorney in the Southern District of New York, correct?
That's right. Yeah. That's a long time ago.
But okay. But my point is, did you ever contemplate novel theories such as this when you were there? Were you guys ever like, hey, you know what? Maybe we can get them like this?
Yeah.
On any case where.
Yeah. What a great question. Well, I'll give you this as an example. I'm so old that I was hired by Rudy Giuliani. He was the U.S. attorney in Manhattan when I was hired to be in that office. And one thing Giuliani did that made him famous was he used the RICO statute to go after mob influence and takeovers of unions in New York. Nobody had done it before. And, you know, he was celebrated for that. That was a novel theory. So it's not always wrong to use a novel legal theory, to use criminal statutes in a new way, as long as it's a solid interpretation of the words in the criminal statute. You know, it happens, and people can be celebrated for it the way Rudy Giuliani was. But I'll tell you, my view about this is you should not be doing that when you're a Democrat elected prosecutor going after the poll leading candidate from the other party.
Right.
This should create special rules, special doctrines. We don't have them yet, but we need them where the law says, hang on, in those circumstances, you cannot be using a brand new, untested legal theory because it just opens up too many dangers of political prosecutions. I mean, there's thousands of county prosecutors in this and local district attorneys in this country. Are you telling me that they're not going to go after the next, like, whether it's Democratic or Republican candidate for president? If this prosecution stands, that's what's going to happen in this country, and that is a disaster and just a recipe for chaos.
I agree, and I wish that folks on the left understood that there's going to be some DA somewhere in America in a red district that says, I'm just going to indict Joe Biden for something because, look, we can do it now. I want to ask you about the judge in a second. You brought up conflicts in one of the podcasts, and I want to ask you about that. But before I do, when you're going through these arguments, and I've never heard anyone question Judge Mershon's credentials, meaning it's not that he's not a smart guy. So this guy, Marchand, has got to at least have thought of a lot of the theories that you have put forward, the Sixth Amendment, all these other issues. Do you think a judge like this cares? Meaning, does he think to himself, hey, I think this might get overturned, but I don't care anyway. I know this is questionable. Or how does a judge look at some of these things? I get Alvin Bragg. He doesn't care. He's throwing mud at the wall trying to get a conviction. But what's the responsibility of the judge sitting there listening to all this? Because from my standpoint, it kept feeling like he was like, sure, let it go, let it go, let it go. I'll let this in. I'll let you take this. I'll overlook that. I'll overlook that. And it always seemed like he was setting himself up for an appeal that he didn't seem to care about.
Yeah, I can't get inside the head of the judge.
Not him, but I'm saying generally, like, do judges, in your expertise, do judges in the back of their mind ever care about that? Or do they say, I don't care. I'm going to decide this on the merits, and that's up to the Court of Appeals to decide?
Oh, they 100% care. Most judges care. What I was going to say is that a lot of people think that Judge Marchand was biased and just made decision after decision, evidentiary, legal, in a way that eased the path, opened the path, made it easier, made it more and more likely that the jury would convict of a felony offense. Now, I'm not endorsing that view. I would never say, on the basis of the evidence that we have in public, that Judge Marchand was a biased judge. We know that he did make a political contribution.
Right. I want to ask you about that. Like, but it was not a significant amount of money, but the bottom line, in my opinion, is why would you make a $20 or $15 contribution if you didn't want people to know where you were? Right. It wasn't like he gave it to some environmental group and you say, well, that's a leftist organization. He gave it to a group whose stated mission was to, quote, stop Trump and the radical right. I mean, he literally said, I want this guy who is in the case to stop.
It's very surprising. And as you might know, he violated New York judicial ethics rules. I mean, judges are not permitted to make such donations, but he did. You're absolutely right. It was a very small amount of money.
But why would you, again, you know this, and I know that the court of the ethics ruling that came down said, hey, not over the line, but doesn't look good. And you're still thinking to yourself, I should preside over this case?
It's strange. You know, I'm not prepared to say that he was legally required to recuse himself, that we had a conflict of interest, the way the law defines it, requiring him to step aside. But boy, this is a case of this magnitude where the appearance of impartiality is so important. You got to ask yourself, maybe he should have resigned.
Right. But is that a grounds for appeal as well? Or is that just, hey, sorry, we've lost that one?
They'll say it. The New York courts have already opined on that. They probably will not get a conviction overturned on the grounds of conflict of interest. And I'm not prepared to say, from what I know, that there was a legally that he crossed the line into legally required disqualification. But boy, you know, I wonder whether you got to think maybe he should have recused himself.
Right. No, there's no question it doesn't look good. If you're going to prosecute the leading candidate for president of the other party and you've given money to an organization whose said goal is to stop that guy, and you gave money also to his opponent, at the very least, again, I get maybe it's not technically a violation, but it doesn't look good.
No. And you know, there's the business about his daughter. Yeah. And again, the facts on this are not clear to me, but
let me tell you as I know, and we can answer it as a hypothetical then. But the bottom line is his daughter runs a political firm. That firm represents several Democratic candidates. It's a Democratic firm. Again, that is not disputed. That's who they represent, including the Biden-Harris campaign. Adam Schiff is another client. Again, maybe she doesn't work on every campaign or every client, okay? But her firm does. And they raise money off fundraising letters, etc., that use Trump as the basis to raise money, specifically Trump's conviction, Trump's legal woes. none of that is in contention. Those are all facts, right? There's no one disputing and saying, well, she doesn't actually work for the company, or they don't do this, they don't represent her. No one is disputing that. Her name is on the website. That's what the company does. The clients are listed. Again, I can't believe, whether it's legal or not, that the perception that your daughter benefits from the outcome of this doesn't, and again, you can answer it from an ethics standpoint, but I can just tell you from a perception standpoint as a layperson, that doesn't look good.
No, it looks terrible. Like, as a total hypothetical, imagine that a judge had a grown-up son or daughter who had like placed a bet, and was going to make money if the defendant gets convicted, some
Right.
online, but this is it's a terrible look, and it's also very questionable. Like, can a judge decide impartially under those circumstances? The law says that if somebody in your household, like either you or maybe a minor child or maybe a spouse, has a financial interest in the case, that's like grounds for legal disqualification. Like, you got to remove the judge, and the judge has to recuse. But believe it or not, those rules don't reach grown-up children. They are considered, maybe, again, it's a question, should maybe the judge.
That's a good. I actually, that's an interesting point, because she's an adult, not under his control, right? She's not a minor child. Hey, she has the freedom to make decisions, and he's not tethered to her anymore. I get. Oh, all right. I could see that. I don't buy it, but I can see it. Let me ask you about this posting. Judge Marchand sends this letter to the prosecution, the defense, earlier this week, saying, "Hey, we got this note on our website. It says that my cousin, who was a juror, said the fix was in. Trump's guilty." Mm-hmm. What obligation does the judge have beyond sending this letter? Should the judge have to investigate it? And is it the basis of a mistrial, as many people are opining?
Well, I mean, you don't want to jump to conclusion in a case like this. The first question is the note legitimate? That
Correct.
Is this guy a crank? Is there really a cousin? The minute I saw this thing, I was suspicious and dubious. And, my cousin was on the jury. I didn't buy it. Now, it could be true, but I was very dubious. My understanding is that folks think they've identified the sender of this, and that it doesn't look like somebody who has a cousin. He looks like a guy who posts crank messages. And if that's the first question, is it legitimate? And my guess is that below the surface, we don't see it. My guess is the court is looking into it, and people are looking into it. Folks are definitely looking into it online, but my guess is there's something of an investigation going on. But that's the first question. And nobody should jump to any further conclusions until we know whether there was any legitimacy. Right.
And okay, well, that's the answer. But I guess the question, I agree with you. I mean, it seems a little too nutty. But does the judge have an obligation beyond the letter to say, hey, we looked into it. The guy doesn't even have a cousin. He's a nut job. He's a certified nut. I mean, whatever. But does the judge have an obligation beyond notifying the parties?
Yeah, well, I think he's notified them. That's a good question. I don't know the answer to that. Does he have an obligation? My guess is that that he's doing one of two things. He's going to let the parties come forward with something and let them investigate in the adversarial process, or he's quietly, told his chief judge and the court system and a marshal or deputies are now also doing what they can to look into it. And, if somebody comes forward and makes the mistrial motion, then the burden is typically on the person making the motion to come up with some evidence.
The thing that was interesting to me, again, as the layperson sitting back, was that the Trump team hasn't really made a big deal out of that, which makes me believe that they know it's a nut job. Because if they thought there was some basis, I think they'd be banging pots and pans. You have also been big into the free speech movement. And one of the things that came up over and over again was the gag order. Whether Trump could make these allegations. And the legal community was like, hey, the gag order is supposed to protect the defendant. Where did you come down, or what do you think of the gag order specifically of Trump talking about witnesses and the DA? Because again, I looked at this and they kept saying he's attacking the judge's daughter or whatever. And I'd say, wait a second. he's not attacking her. He's pointing out what she does for a living, which I think is fair. I don't know that that's an attack. Saying that Michael Cohen's a scumbag is a fact, not necessarily an attack, because he's a convicted perjurer. What was your take on the gag order?
Well, gag orders, have been upheld in criminal prosecutions because, criminal defendant is not permitted to try to intimidate or threaten witnesses. But this gag order went way beyond that. And in my opinion, it raised very serious constitutional First Amendment questions. I don't believe that a judge has the constitutional authority to stop the criminal defendant from criticizing the prosecutors or stating true facts about, let's say, the judge's daughter. I mean,
right.
I feel sorry for the judge. I feel sorry for his daughter. You feel sorry for the family. There's who the heck knows what people are going to do when they start seeing this. People can react in terrible ways. Maybe they're sending her terrible emails. I have no idea. But all the same, a criminal defendant has every right to say, look, tell the world this is what's happening here. You guys don't know it, but we just discovered these facts about the judge's daughter. You cannot gag somebody from telling the world true facts that call into question the impartiality of the process. It seems to me is basic.
I agree. It wasn't like they were doxing her and saying, here's her phone number, call her or something. He was saying, I want you guys to understand why he's making these motions, at least in our belief, because we believe that, this, and we believe that so-and-so is saying this because I think there's a difference between attacking somebody and intimidating them and stating a true fact. Speaking of which, I wanted to ask you this because I've enjoyed your videos and your podcast because I think it really does break down these complex issues in a very methodical way, right? It's here's the law, here is the circumstances, and here's how people are, and then you literally do this Q&A, which I find fascinating. But you're at Yale, and I've got to imagine that the people at Yale, and don't necessarily want that discussion. Am I wrong in that, or is there an open discussion and free exchange of ideas among you and your colleagues?
No, I think you're right about that. It's become embarrassingly difficult at Yale and many other fine institutions, law schools, universities for folks to speak their minds, speak freely, and I can't stand it. And what I'm trying to do with this, the podcast, the YouTube, the X videos, I'm just trying to explain to folks what's happening in these cases. People read about them, they see them, and they don't know what's going on. And also, there's so much partisan stuff, and I just can't stand it. It's like we've got to have a way of talking about serious legal issues in a nonpartisan way, and so that people can understand it, think for themselves. I wouldn't say that what I'm doing is attracting a big fan base at Yale Law School. No.
But is it? I mean, again, I think let's just take the Sixth Amendment real quick. Like you bring up a very legitimate thing, and even in the discussion, you're saying there is a legitimate grounds. You're not siding with anybody. You're saying I believe, and this is what I loved. I took con law one class when I was in college, and I loved it because it was like make this argument or defend this. And I feel like you're bringing up great sort of existential questions. Is this a violation? And here's how that to me is what learning is supposed to be about. And I feel like we're having the ability to have those discussions are stifled. It's even if you suggest it, you're a bad person.
Yeah. I don't know when this started or when this grew to such proportions over the last 5-10 years. It's just an embarrassment to academia and even legal academia that you cannot just have a conversation and express certain constitutional views, express your views about, whatever they happen to be. And you get, ostracized for it. It's just terrible. And I won't have it. I can't stand that stuff. So I'm trying not to pay any attention to it. And I'm going to, my goal through these podcasts is just to, give people a way of understanding what's going on and let them see what the serious issues are. And I don't care what anybody's going to, if anybody wants to criticize me because maybe it might help Donald Trump. That's not the point. The point is to give an unbiased view of the constitutional issues.
Well, I certainly appreciate it. And I learn a lot. And that's what I think is great, is The arguments are interesting. The questions you pose are compelling. And so I appreciate you doing that and putting yourself out there. The easy answer in so many cases these days is to do nothing and to say nothing. And I appreciate you putting yourself out there to help us better understand our system. It's important, especially in these perilous times. Thank you for joining us and giving us your expertise and your insight. I really appreciate how generous you've been with your time.
Thank you, Sean.
All right, guys, thanks for checking this out. I hope you've enjoyed it as much as I have. We've got a great lineup all next week. Continue to subscribe on YouTube, Rumble, iHeart, Apple Podcasts, Spotify, wherever you get your podcasts. And we'll see you back here next weekend. Have a great weekend. We'll see you on Monday. Well, if you enjoyed this content, make sure to like this video, subscribe, and click the notification bell to get more.